Senate Judiciary will be in order. Senator Ausler is going to lead us in the pledge. Yes, you're doing such a good job. Allegiance to the flag of the United States and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice. Thank you, Senator. Kelly Potenza, Representative, come on down. Good to see you, ma'am. Tell me about 697.
Thank you, Mr. Chair. And for the record, Representative Kelly Potenza, Stratford District 19. This is a pretty simple bill. It actually left Judiciary in the House on fully supported, passed the House on consent. This bill basically came to me from a relationship I have with a prosecutor and some other people in the judicial system in Coos County. And it has a lot to do with, of course, I know some of the bail reform laws will hopefully make some changes to this, but I realized that some people were losing witnesses. And it's a big deal because, of course, you know, a trial is set. The first time, you know, they're compelled to come testify. And then if there's a no-show, that's it. That's the one and done. That's your kind of like your civil duty. But after that, we're talking about 3, 4, 5 time no-shows. And the prosecutors are losing witnesses in these criminal cases. It's a huge issue. And I can't believe that we haven't fixed this, and to expect someone to take their time when they're trying to help a case. You know, of course, these could be in misdemeanor or felony cases, but to try to take the time off of work and come and travel, sometimes very far, and then not to be reimbursed, and expect them to do that multiple times when, of course, the defendant pulls no-shows is just, it's ridiculous. So I put this bill in to have compensation on mileage. I think that should probably be compensation on mileage the first time, but this is just the kind of like the first bite of the apple, and it's because of the problem of witnesses that have showed up multiple times, and then of course there's still no trial, no hearing. So that's this bill is really to correct a kind of a little bit of an injustice that's going on, and to get some witnesses compensated, just basically their mileage to attend a hearing and be a witness for, you know, the state.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. The fiscal note hasn't been updated since, I guess it was in the House. So how much is this going to cost, and who bears the cost? Is it like where's it going to, what department is this going to come out of?
I don't know how much it will cost. All I know is that it's the mileage rates from the federal, and it would be the state that would be paying for this if a prosecutor needs those witnesses. You know, whether it's of course a local town, a municipality. You know, these are all the prosecutor is requiring these witnesses to make the case for the state. Then the state pays for this.
May I follow up? So I'm looking on lines 6 and 7, and it says the civilian witness shall be entitled to a payment for each day of attendance and mileage for each mile's travel to and from the place of testifying. So what is how much is the proposal for that second? I understand it's only if there's a second day, right? Or a third day.
Correct.
So how much?
The mileage is how much?
No. The fee. Payment for each day of attendance and mileage. That's
Yeah,
the way it reads. You're paying
all I was
someone for a
putting-
hearing.
The bill is, I don't know what that is already. I don't know what that price is. My whole bill was just for mileage, so I'm not familiar. I was basically, the fees was the mileage. So I don't have any other information in that. So I wasn't expecting whatever fee. I don't know what that is. If it's
I see.
a jury gets paid, I have no idea. My whole point of this bill was mileage.
So you want that out, is what you're saying?
It's your bill now. If you think it should come out, I don't know. I mean, the whole point of this was for mileage.
Got it.
Thank you for your testimony. Any other questions? Yes, go ahead.
Thank you, Mr. Chair, and thank you for taking my question. I'm just curious, I looked to see where this fit in the statute here, and the existing 51616 has been repealed. Do we know, so there is no existing law right now that says that they get mileage and their witness fee?
Correct, they get nothing right now.
They get nothing.
It's awful.
Further
Follow-up.
question?
Yep.
So I'm thinking there has to be a system to say, we did call Kelly on this day and she appeared and not. So should people have to be maybe subpoenaed for it to be official that they were called that day? So somebody can't just,
So all of that automatically happens. So for example, so let's just say I was called to come to court first time around. And because that one's a given, you're not paid for that one. It's kind of like your civic duty. I mean, if we wanted to amend it if you guys wanted to amend it to do that, that's fine. I mean, I really believe that people should be paid mileage in doing so. But in any case, and the defendant pulls a no-show. Every single time, all of the court documents will have another subpoena for that witness. But that's where we're losing witnesses. It's still active. There's 3 witnesses in a case up north. It's unbelievable. And the defendant has not shown up 7 times. Those witnesses, she's already lost one of them. They're not even bothering anymore. But those 2 people have literally gone back and forth. One has to drive an hour back and forth to the court on 6 separate occasions for nothing.
Thank you. All set. Thank you for your testimony. Rep. Jonah Wheeler, come on down. How goes the battle? You winning?
Always, Mr. Chairman, always.
Great.
Thank you, Mr. Chairman, members of the Senate Judiciary Committee. For the record, my name is Representative Jonah O'Ryan Wheeler, and I'm just here to affirm my support for this important legislation as a co-sponsor. That's really all I came up here to do, was affirm my support as a co-sponsor. But to answer Senator Alschuler's question about the fees, under U.S. Code 18, Attorney Enders can expand on that more. He's the one who told me about it. It's a $40 charge that is given to them. And there was one more thing I wanted to say, but I'm blanking on it, and that's the danger of not writing it down. So with that, Mr. Chairman, I think this is an important piece of legislation that passed the House unanimously, and I support it.
Thank you. Go ahead, Senator.
thank you for taking my question. So the US code is federal law. So in federal court, they're paid a fee,
Correct. Yes.
but not in state courts.
Correct.
Thank you.
Yeah.
Appreciate it.
Thank you very much for your testimony. Does anyone else wish
Thank you,
to
Madam.
testify on this bill? Attorney Enders.
Good afternoon. My name is Stephen Edris. I'm an assistant county attorney in Merrimack County. Just to answer some of the committee's questions, there used to be under 51616, I think it was, you got a fee for $12 for each half day and 17 cents per mile. The way that used to work is those fees were paid by the Attorney General's office. When a witness came to court, there was a sign-in sheet. The witness would sign in. the prosecutor then has to essentially sign in and confirm that that witness was in fact subpoenaed. The federal fee is $40 a day, as referenced in the statute. And I believe that the mileage rate under the federal law is the standard IRS mileage rate, which is in the ballpark, I think, of 65 cents-ish a mile, although I'm not exactly sure what that is currently. Happy to answer any more questions.
Thank you very much. Do we have any questions? Seeing none, thank you very much.
Thank you.
Does anyone else wish to testify on 697 who didn't sign in? Seeing none, we'll adjourn the hearing. We're going to take a 1-minute recess. Judiciary is back in session. I have making a motion to go into executive session. A couple of seconds. I think we're good on that. So, what's that? Yeah, no. First, I got an OTP, motion to brought to pass. Oh, okay. That would be a simple thing, wouldn't it? Motion to go into executive session, seconded, and all in favor of the motion?
Aye.
Aye. Okay, I motion ought to pass on the underlying bill 778. Do I have a second?
Second.
Discussion? I think we're all set. Okay. Now I'd offer my amendment B, right? So I'm going to offer amendment 1382S. And I think we've all had a chance to look it over. And any discussion?
I saw this, I'm just doing the side by side with.
Yep.
Oh, we can send her this out.
Yes, it is. Is it the same one she, okay, it is, I'm sorry, it's hers.
See if there was any differentiation, and I'm like, I'm not seeing.
No, it's hers, I'm sorry. I thought my name was,
1382 is.
okay. All in favor? You have, good. It is.
Yes, second.
All in favor of the amendment?
Aye.
Aye. So 4 for ought to pass. And now I motion ought to pass as amended.
Second.
Thank you. Discussion? None. All in favor of the ought to pass as amended? Aye.
Aye.
All in favor of the consent motion? Aye. You want to bring it up? No. Senator Oshler, would you like to take this up? Okay. I'll take it. Okay. Sounds good. Motion to move out of executive session.
So moved. Second.
All in favor of the, thank you. Okay, back in the game. Representative McDonald. How you doing this afternoon? Good. Pretty good is good. Anything above 50, 60 is good. Good to see you, Representative. 218, tell me about it.
Thank you, Mr. Chairman. My name is Representative John McDonald, and I represent Cal County District 6, which is the communities of Wolfboro and Tuftonboro. This bill in a nutshell is basically to provide a victim of a crime a free police report. I passed out of the House on the consent calendar. And since its passing, some stakeholders have been working together to make the bill a better bill. Right at this time, I would say we're 99% in agreement on an amendment. We're just not quite over the finish line. I'd like to ask your indulgence to continue this hearing for another week or whatever is convenient for you folks to hear this bill again with the proposed amendment.
Am I okay with putting that aside, Pete? How would I do that? Okay. Sure, okay. Thank you. Well, no real questions. Thank you for your testimony.
Thank you for your understanding. Appreciate it.
Stephen Hindris, come on back down.
Again, for the record, my name is Stephen Andrews. I'm a prosecutor at the Merrimack County Attorney's Office. I'm one of the stakeholders that's working on this and happy to answer any questions, but I think we're close, but not exactly at the finish line.
Okay. Go ahead, questions.
Thank you, Mr. Chair, and thank you for taking my question. So I hope that this is coming forward in the amendment. When there is a crime, there is a victim.
Yes.
Who committed the crime is still the question. So this just pertains to the experience that a person had and getting a copy of the police report post their experience. Just them, not witnesses, not other people. If it was a group, I don't know. Tell me, like, where are you going with this amendment? That's kind of, I would like a little heads up, maybe.
Yes. So there's, in my opinion,
Yeah.
what's difficult is that there's concerns with providing a victim with a copy of the police report prior to a trial. And I say that because the defendant has a right to a fair trial. Once a police report is provided to a victim, that victim can theoretically do whatever they want with the police report. So I have a concern that if a victim is provided with a police report and they decide to, for example, publish somehow that police report, that could theoretically impact the defendant's right to a fair trial and affect the ability for that person to be held accountable for the crime they committed. The second concern I have is that in a trial, the state has the burden of proof. So the state's witnesses obviously testify first. And then if the defendant wishes to testify, they've essentially sat through the trial and have seen what those witnesses have testified to. Normally in a trial, witnesses are sequestered, meaning that they're not allowed to talk to each other or talk about the facts of the case during the trial. So in a normal trial, for example, witness A can't testify and then walk out into the hallway and say to witness B, hey, this is everything they asked me and this is everything I said. So witness B can sort of tailor their testimony to what witness A said. The defendant obviously sees everybody testify, and there's case law that says one of the things you can say to impeach a defendant is essentially, you had the benefit of sitting here through this trial, you knew what everybody's testimony was, and you could have tailored your testimony to comport with what they've said. One of the concerns that I have about giving witnesses or victims police reports is that same sort of theoretical cross-examination could be used on the victim. That you could say to the victim, isn't it true that you've read the police reports? So you knew what the officers were going to say, and perhaps did you tailor your testimony to what those officers said? So that's one concern of mine. Another concern of mine is that there's information. The proposed bill has both police reports and the entire case file referenced in it. There's concerns about information in the case file itself. Some of those things, for example, criminal records. We have to provide witnesses' criminal records pursuant to the rules of criminal procedure in New Hampshire. Those records are confidential by statute. And I don't know if the intention is that we would be giving witnesses or giving victims, other witnesses' criminal histories. We may have medical records of third parties. We may have mental health records of third parties in our file. And I'm not sure we want to be giving those to the victim without some type of redaction of that information. So I absolutely support giving victims information and giving them police reports. I have concerns about doing it pre-trial. I have much less concerns about doing it post-trial. I do think that the idea of confidential information needs to be addressed. And I understand that there's certain things that a victim wants a report for. For example, they may want to let their employer know that I was the victim of a crime and I'm going to need to leave work or not be at work for a period of time. I think there's statutes regarding landlord-tenant where if a victim is a tenant, they can't be evicted for periods of time. I think that the amendments we're working on address all of those issues. Under the current Victims' Bill of Rights, there's the right to have the prosecuting attorney notify the victim's employer. And one of our thoughts was to expand that to have the right to have the prosecutor or law enforcement notify any third party on the victim's behalf. So that's sort of where we're, in my opinion, hopefully headed.
Thank you. Thank you. I really appreciate that. Thank you.
Senator Ridden.
Thank you, Mr. Chair. Thank you for taking my question. I think in the vast majority of cases, sometimes the victim is obvious. In some cases, do you sometimes find out that the victim actually is another co-defendant?
Potentially, since this is an amendment to the current Victims' Bill of Rights, victims defined within that statute already as a person who suffered harm from a crime, and then crime is defined within that statute as well. So I don't think we're going to have tremendous difficulty in that arena.
Follow up? This is within 7 days of the event, though, right?
That's part of one of my concerns is providing things within 7 days of the event. There's, as you can imagine, ongoing investigation, and police reports may be voluminous in certain cases. I know in certain sexual assault or murder cases, I've had 3 or 4 bankers' boxes of police reports and paperwork. I think that the goal of this, when it references the initial report, was essentially to get something in the victim's hands that they can use to show, their landlord, their employer, whoever they need to, what's going on. And under the current Victims' Bill of Rights, they do have a right to know sort of the status of the case. So they should be given a lot of this information anyway.
Thank you very much for your testimony.
Thank you.
Does anyone else wish to testify to 218 who didn't get to sign in or came in late? Seeing none, that ends. I do. I'm sorry, Pam, I thought you checked off. Okay, yeah, you checked off no, and you don't have to. I'm glad you're here. Good to see you, Pam.
Hi, for the record, my name is Pamela Keilig and I work at the Coalition Against Domestic and Sexual Violence here in New Hampshire. I just wanted to say we support the bill and are grateful that the sponsor is bringing this forward and are in the process of also working with the stakeholders on the amendment. We really appreciate that hopefully this is something we can see move forward this session and appreciate the extra time. Happy to answer any questions or provide additional information, but thank you so much.
Do we have any questions? Nope. Seeing none, thank you very much for coming up. And that will close 218. This is, I was looking for a rep. Oh, what's this? Oh, the last one, okay. Okie dokie. I was interested in this too. Do I have a rep who could read it in? Tricia, can you read things in, or should I? Okay, thank you. I don't have, the representatives aren't here who are the sponsors. So it's, I can give you a call, we can go. 109. Oh, you're here. I'm sorry, Mr. Manning. Saves you. Tricia's happy. Representative Manning, good to see you.
Thank you. For the record, Representative Dennis Mannion, Rockingham 25, I represent Salem. House Bill 109 this was a bill that was filed last year. I think it was House Bill 400 with this bill and the following bill that you're going to hear after this in one. I separated it into two. I also changed some of the language to lessen the penalty on each. So what this bill does is it adds two separate parts to the statute for filing a false report against a law enforcement officer in two parts. The first part is for misconduct of an officer. And that would be, so if you come in and you knowingly file a false claim against the officer for misconduct, that you could get charged with a misdemeanor. The second part of that is if you knowingly file a false claim against a law enforcement officer that is a criminal conduct, that would be a Class A misdemeanor. So I made that one a little more severe. Last year, I think they were both A misdemeanors. I didn't think the the misconduct should be the same as a criminal act if you falsely accuse an officer of that. So that's essentially what this bill does.
Okay. Are you done?
I'm done. Thank you.
Okay, thank you. Do you think, you probably don't, but do you think this is going to make people afraid to file these reports, that is it going to have a chilling effect on people coming forward?
No, and I heard that in the House hearings. So knowingly is a pretty high bar. The person is aware that they're filing it and it's false. I know I'm lying, I'm making this up. This isn't retaliation for arresting my brother or my mother or me or whatever. So I don't see this having any effect on people who come in. And if you file a claim against an officer and it's unfounded, that's not going to automatically trigger this.
Okay,
There's a high bar there to prove knowingly, so.
gotcha. Any other questions? Go ahead, Senator.
Thank you, Mr. Chair. Thank you for answering my question. What brought this forward? Were there incidences in your district, or where did this come from?
So I probably should have said this ahead of time. I've been in law enforcement for 30 years. I retired in 2015, and I'm currently working as a part-time police officer. So I've seen it in my career where people have come in and made false allegations against law enforcement officers, both for just misconduct and also for criminal activity. And in the past, it's just been, there's no harm in doing it. The worst case scenario is nothing happens to me, the person who's filing it. The best case scenario is the officer gets in trouble and maybe my case gets dropped. So there has to be some type of deterrent and a penalty for people who do that if it's strictly for a knowingly false allegation. So that's what brought this about.
Yeah, follow up. So when someone comes forward to a county attorney's office and wants to file a claim against a law enforcement officer, it triggers a investigation at the law enforcement agency.
Correct.
And that person has put themselves forward in the eyes of the law now. So the county attorney is aware of who this person is. You can't do it anonymously. So I guess you may have answered my question in speaking with my colleague, Senator Gannon, that it's your opinion that it does not create a chilling effect, that people may not bring forward police misconduct because they are afraid of legal retribution?
Correct. Knowingly is a high bar, and technically, it's already in statute that if you file a false report of any kind, there's already a penalty for that. This just enhances it if you're doing it in retaliation for a law enforcement officer. So, I mean, essentially, it's in there, it's just a misdemeanor for criminal offenses. This just bumps it up to a Class A misdemeanor. If you falsely accuse knowingly, I'm going to report this officer because he arrested me, and I'm going to go down there and file a false claim against him in hopes to get my case dropped or in retaliation. That's what this is geared towards. It should have no effect on anyone filing a legitimate complaint.
Thank you.
Senator Abbas.
Thank you, Mr. Chairman. Thank you, Representative. It's good to see you. I understand the false side of this. What about the baseless information? I guess it's one thing to file something really and not have much information to work with, but you believe it to be true. Something to clearly misrepresent facts and you can demonstrate that they can.
Yeah, so this was a bill, like I said, that was filed last year. I took the language right from that. My interpretation of that baseless information was the same as false. It's, it didn't occur. So if you say that an officer, assaulted me while he was putting me in the back of the car, he punched me in the face, and there's no basis for that. His body cameras showed that that never occurred. My intent or my thought was that was baseless information. There's nothing there that says it. You can prove otherwise.
A follow-up. So if false and baseless, if it's kind of in the same boat, would there be an objection or to perhaps just striking the baseless information section?
Absolutely not. I think false will cover it.
Thank you.
Any other questions?
And that's in both sections.
Yep.
The baseless information, yes.
Thank you very much for your testimony, Representative.
Thank you.
Does anyone else wish to testify who didn't sign up? Seeing none, we'll end the hearing on the bill.
Oh, I was in children's family. I came, my
So, and then there's one. Representative Manning, good to see you. And I guess we're going to 59. Tell me about 59 FN.
Thank you, Mr. Chairman, members of the committee. So this bill here is the second part of that bill that was filed last year, so I separated them, like I said. So I'm not inventing anything new here. This can already be done, but there are steps to it before this can happen. There's some enhanced penalties and stuff. So the bill basically makes it a Class A misdemeanor to knowingly cause serious bodily injury to public safety people, to include firemen, on-call or volunteer or paid, EMS people and police officers. And then it would make it a Class B misdemeanor to knowingly cause bodily injury to the same category of people. So right now in statute, you could charge them with assault and then seek an enhanced penalty. There are some hoops you have to jump through to do that, including notifying the defendant prior to, in writing, that you seek enhanced penalties. The judge has to review that and may or may not accept that. So there are three reasons why I'm filing this. One is to send a message that we want to protect our public safety officials from assault. It sends a message to the state by just giving it its own statute. Number two, it sends a message to the judges that if someone assaults a police officer, that they should be charged, and there's a slight enhancement to it that we don't have to go through the enhanced penalty process for. In my experience as a police prosecutor, I have filed assault charges on behalf of officers, and the judges have dismissed them. And they've told me that that's part of their job, to be assaulted, and I won't entertain any assault on police officer charges. And the third reason, probably the most important reason, is we can track this stuff. If somebody assaults a police officer and they have it on their record, we'll be able to determine that when we run a record on somebody we're investigating. We'll know that, look, this person is known for assaulting public safety officials. Use extra caution when dealing with them. So those are the three reasons why I wanted to file this. Again, it doesn't invent anything new. It simply gives it its own statute. That's it. Thank you.
And my only quick question, knowingly was a very placed word, right?
Correct.
In each paragraph.
Yes. Initially, the second part had recklessly in there, which I removed in the House because I think knowingly is a high bar. Being aware of it, knowing that what I'm doing, this is the purpose of what I'm doing.
Thank you. Any questions? Sandra? No? Okay. Thank you very much for
Thank
your
you.
testimony. Holly Stevens. Afternoon, Ms. Stevens.
Good afternoon, Chairman and members of the committee. My name is Holly Stevens. I'm the Director of Public Policy at NAMI, New Hampshire, the National Alliance on Mental Illness. On behalf of NAMI, I am here today to speak in opposition to House Bill 59 because of the impacts it will likely have on folks with mental illness. I do believe that it does create a felony level offense for one of them. The bill that you have out back is as introduced, so I don't have the one that was passed by the House in front of me, so I apologize for that. But I would call your attention to that. I think one of the offenses is a felony level. NAMI New Hampshire firmly believes in and supports the critical services that our first responders provide to the safety and well-being of our communities. Oftentimes, individuals with a mental health crisis find themselves interacting with first responders on some of the worst days of their lives. We find that first responders are an important element of mental health crisis response, and their safety and well-being must be protected. However, we have significant concerns that House Bill 59 will significantly and punitively impact individuals in a mental health crisis, and believe that people in crisis deserve treatment and support, not to be arrested, jailed, and faced with disproportionate penalties. Under current law, as I think you all know, police cannot arrest a person for a misdemeanor offense unless it's committed in front of the officer. or if certain conditions are met. Senate Bill 59 instead for the misdemeanor level offense, which is in Section 3 of the House as amended by of the bill as amended by the House. It would provide for a warrantless arrest of any individual accused of simple assault of a first responder by raising what would otherwise be considered misdemeanor simple assault to the level of a felony. As mentioned earlier, folks with a mental illness often interact with first responders on the worst days of their lives. Thank you. And as such, their actions may be reckless or unpredictable and may result in bodily injury. Therefore, we expect that this bill would cause more individuals with mental illness to often face higher penalties established in this bill due to their frequent interactions with first responders. There's also concerns around the provisions on bail in this bill. It would make obtaining bail more difficult, resulting in more folks with an active mental illness residing in jails around the state. The bill, as passed by the House, allows for no discretion of the court, stating that if the court finds probable cause that either of the offenses contained in the bill has occurred, and it's, quote, that finding shall constitute prima facie evidence that the defendant is dangerous. And so when considering bail, those two sections of the bill would only lead to folks with mental illness spending more time in jail, not getting the treatment they need. Further, these sections are unnecessary as under the new bail reform, there is already a mechanism to determine dangerousness for these crimes. While the committee may determine that there is a need to provide increased protections for first responders, there must also be a balance in protecting the rights and freedoms of individuals with mental illness. And it's paramount that people in psychiatric crisis continue to have the due process protections afforded to them under law. If this bill passes as amended by the House, again, we just expect that more people with a mental illness are going to end up in jail for longer periods of time when they are in crisis. And in addition to providing you my testimony, I also provided, I worked with Karen Rosenberg of the Disability Rights Center, and we put together a track changes version of what we are proposing as an amendment. It would change one of the knowingly's to purposely, and it would also strike out the provisions on the finding of dangerousness, as well as suggesting a study committee to look at what the impact of this law is over time as it goes forward. We did work with the House and did make significant strides in this bill from the way it was introduced. So we appreciate the work that the House did with our concerns, but we do have some additional concerns. So for those reasons, we are still opposing this bill, and we just suggest that you take a look at it and maybe consider the proposals that we're putting forward.
Thank you for your testimony.
Thank you.
Quick question for you. So where they have that word knowingly at the beginning of line 3, line 18, doesn't that protect your disability person or person with Alzheimer's, because they wouldn't be able to form the mens rea? They couldn't, they're lacking the capacity to knowingly do this crime. Isn't that going to protect those people?
It'll protect a number of those folks, but there may be somebody who in crisis knowingly knows that they are striking with a punch. They don't have the understanding, or they're not purposefully wanting to cause harm. That is not why they're doing it. They're doing it to protect themselves. And so, yes, they may knowingly do something, but under the difference between knowingly and purposefully, that's why one of them we changed to purposefully, because it's really, you know, did they intend to cause the harm to the first responder? Did they know it was a first responder at the time? You know, were they in full-blown psychosis and they're seeing somebody come at them, they think that they are an enemy, and they, yes, knowingly strike out, but they're not intending to cause injury to a first responder. Does that make sense?
I understand where you're going, but I'm listening to your testimony. So other questions? No, Senator Evans? Questions? You all set?
I'm all set.
Okay, surprising. Yep, go ahead, Senator.
Yeah, thank you, Mr. Chair, and thank you, Ms. Stevens, for taking my question. So going back to purposefully and knowingly, if knowingly stays in this bill and it were to go forward, then genuinely, there will be more people who were experiencing mental health crises who then end up in our jails where we do or do not have adequate services to address those mental health issues.
We have heard from the counties over and over that they do not have the services to provide for folks in the jails, and that they have, I heard from one of the superintendents at one point testifying, say that they have people banging their heads off of concrete walls, and this is not the place to have folks who have a mental illness. So that is the concern, is that if they're in jails for a longer period of time, in a mental health crisis. We're not talking about folks that are not in a mental health crisis, but when they're in the mental health crisis, that yes, having word. I will say though that, as I mentioned, as introduced, the bill had in it recklessly. That was amended out, and so we do appreciate the fact that the House took the time with this and did make some amendments to it. Knowingly was certainly an improvement over the version that the House started with.
Follow up.
Yes.
Purposefully, it was my understanding that purposefully is better, but maybe putting this on hold would be even better.
Yes.
Okay, final follow-up.
Yes, ma'am.
In going through, I know I've seen you here at the State House in this committee. It's nice to see you again. But we also understand that as we move through this budget year, that mental health services are looking at a severe deficit in resources. And we've heard testimony from our community mental health centers that they are underwater in uncompensated care costs. So when we potentially say that we have more people who potentially who are in unaddressed mental health crisis situations, who then come in contact with law enforcement in a negative way,
I'm going to
we are
stop you,
looking at
Senator.
possibly
I
going.
think you're getting off track. I think she's testifying here, and now I don't think you're sticking with the purpose of what we're doing. So just, I think we're going into the weeds astray here.
That hearings were for the point of getting in the weeds. That's where.
Yeah, just, if you could just ask her a question and she can respond. It just seems like you're leading her to say something here. And
Okay.
we're looking for her testimony.
I'm looking for your testimony, please.
Yeah,
If you could give us an overview of how you see this playing out, given the landscape today.
I've spent the last week in Division 3 over at the House, where they have made significant cuts in community mental health. They are suggesting that the state sell the Philbrook building, which is currently housing 16 people in transitional housing. They're suggesting that the Terrell House be sold, which is housing some folks that are homeless right now. And I'm just saying that with the cuts that are potentially happening, I know that you guys haven't gotten the budget yet, but with the cuts that are potentially happening, we are not going to have the services for these folks even in the community.
Thank you.
Can I go back and just help me just with knowingly?
Yes.
So you were talking, we have someone who's suffering disability, Alzheimer's, whatever they have. And you were saying that they might know that they're striking to hit someone, but you were saying that they don't understand the consequences of their action. They don't know the injury is going to. So would that be covered not covered? They weren't knowingly aware of what was going to happen. I'm just trying to figure out if the word knowingly is covering enough, more than you think.
I've got the definitions in front of me right here.
Okay.
Knowingly is a person acts knowingly with respect to conduct or to a circumstance that is a material element of an offense when he is aware that his conduct is of such a nature or that such circumstance exists. Purposefully is a person acts purposefully with respect to a material element of the offense when he is conscious, when his conscious object is to cause the result or engage in the conduct that comprises the element. So one of them is really looking at the result, I am trying to hurt you, I am trying to, whereas somebody could be pushing somebody away to get them away from them, but not to hurt them. And so I think that that's the difference between the two of them.
Thank you very much for your testimony. Do we have any other questions? Seeing none, thank you very much for
Thank
your
you so
testimony.
much.
Appreciate it.
Mr. The RSA on like culpability is 626. The RSA on culpability is 626, section 2, I want to say.
Thank you. Does anyone wish to testify? Okay, 2, okay. I don't think I had to, whoever wants to go first. Come on up. 26.
I thought I had signed up, sorry.
That's okay.
I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center, the state's protection and advocacy system for people with disabilities. And we are in large agreement with NAMI New Hampshire that this bill, first of all, it's not necessary. As the sponsor acknowledged, our current law already makes it unlawful to commit first-degree felonious assault or second-degree felonious assault against anyone, and we have enhanced penalties if the person who is the victim of that crime is a first responder. But we did hear at the public hearing on the House side on this bill, a lot of first responders came out and people who had been injured. And what was really, one of the things that was really interesting and just horrifying is that some of them felt that their cases were not being prosecuted and that courts, people had an attitude like, you signed up for this, which we know they didn't. And so, but I don't know that this bill, if it passes, is going to actually have the impact of reducing assaults against first responders or serve as a deterrent, at least from the perspective of we come from a disabilities rights lens. So at the Disability Rights Center, besides being concerned about people who experience mental illness, we're concerned about people, for example, with Alzheimer's or dementia, who really, might intentionally go out and try to, wail on someone trying to help them, not know that they're a first responder, not understand, and actually cause serious harm, which is terrible. But it's also something that they couldn't purposefully do anyway. We're also concerned about people who have intellectual or developmental disabilities who might be in a similar position, or someone who has a traumatic brain injury. I'm probably forgetting other kinds of disabilities that could impact a person's ability to engage in the way we would want folks to engage with people who are there on the front lines to protect all of us. I get that. We also don't know really what the breadth of this issue is. We heard from some first responders, or the House committee heard from some first responders who were injured. And we also heard from some first responders who, in interacting with people with disabilities, tried not to, tried to work with them, calm them, and maybe they had the skills, maybe they didn't, maybe it didn't work out. But some people really genuinely tried. But this would affect every first responder, not, maybe the first responder whose training was a long time ago or didn't have training in de-escalation, for example. And then we'd be really concerned about people who experience a wide variety of disabilities ending up being imprisoned in our county jails that, besides the fact that it would be pretty traumatizing to the person, they're not going to get the mental health treatment. They're not going to have people who, can, if they have Alzheimer's or dementia, enable them to relax, feel, understand where they are, what's going on. So for all those reasons, Holly, Ms. Stevens and I were working on an amendment, we tried to consider, maybe this is something that we could study further, because we're not confident that if this passes, that it really is going to address the issue, the problem. And so if there could be a further study of this, if this bill does pass, we might be able to get a better understanding of, well, what's going on right now, and has it had an impact, and has it had the desired impact? And if so, or if not, why not? Because maybe there are other factors that could be addressed legislatively. As far as, have you gotten, I mean, the purposely knowingly, I know is a bit, challenging to get our heads around a bit. Do you feel I can talk about that more if that would be helpful? If not, I don't need to.
Good, thank you.
You're good with that? Okay, good. And then I think Holly did talk about the other thing we're proposing is to remove the presumption of dangerousness, because again, what this would do is if someone in fact is arrested for this type of felony level assault, a judge is going to be able to assess whether they're dangerous or not. And so we just thought it could be even more harmful to create this presumption that they might have to overcome. And I'm happy to take any questions.
Nope, I think we're all set.
Thank you all so much.
Thank you.
Sorry, Mr. Chairman. Can I speak briefly on purposely knowingly?
Sure.
If you do, that's fine.
Sure. No, I'll listen. Sure.
Just a little-
That's why we're here.
Thank you. Representative Mannion again. So, like I said, knowingly is a high bar. If you change it to purposely, you're actually going to make it more difficult to charge and convict somebody today than it is today to actually do it with the current statute. So you would actually make it harder. So that would actually defeat the purpose of the bill. Thank you.
Thank you very much. Representative Kay, how you doing?
Well, I am really appreciative of being still able to participate as a student of our whole culture and having courts that we can actually, having legislature that we can actually input. My family in Texas, the trip to Austin and so many people,
Sure.
they don't have the same opportunity. I noticed a couple of things. One is I was glad that you were discussing the definition of purposefully and knowingly. As what I understand, purposely means you deliberately did something, but you're unaware of the legal implications. But knowingly, you are aware of the legal implications. I'm hitting him because he's a cop, or I'm shooting him because he's putting out a fire I set. I think in a bill, rather than hope that people interpret, not everybody's a lawyer who has to apply the law. I hope you spell it out instead of just using a word knowingly or purposefully. We're talking about this bill, in my opinion, is aimed at stopping people who, when I was a kid, would have been sentenced to death for killing a cop. And I don't know if they were smart enough in those days to think that you should get the same punishment for killing a responder, but you just didn't kill cops. But now they get killed regularly because there is no death penalty and they know it. I'll shove in the clutch, have different points that aren't necessarily totally related. New Hampshire prisons are really thoughtful about treating mental illness. And when somebody is violent and mentally ill, they do need to be restrained. Now, I'm not sure how you could write this in there, but a lot of times violent people who are mentally ill, if you don't want to put them in jail until you can calm them down, where do you want to put them? Do you want to take them to the ER? Well, it's better spell it out here, because that's a really serious issue that needs to be dealt with. We do have a lot more mentally ill people now, probably because of drug addiction. And one of my friends shook her head when she listened to other people testify, this is years ago, about innocently thinking that you can easily restrain people. She said, I used to repair medical equipment. I'd be in the ER. And they'd bring these guys in or women who were on drugs, violent. She said it would take several people to restrain them. So we have to talk about this not just because oh, these poor mentally ill people, we've got to strike this whole bill because mentally ill people could get caught in a trap. Well, for one thing, somebody has to restrain them until they can be assessed and treated. And I'd rather them not be in an ER if that's how they're acting. But the real purpose of this bill is to make it pay if you decide you're going to take out or maim a first responder, whether it's a person putting out a fire that you want to burn successfully because you got insurance on it, or you're just mad at somebody, or you don't like cops because you've been arrested a few times and you don't care. That is the point of this bill. And we cannot look the other way and say it's not really a serious problem. Well, one cop getting killed, one fireman getting killed, it's a serious problem. How many do you need to make it a serious problem? The other issue that's affecting all this thought about being concerned about mentally ill people, we definitely do need to be concerned about mentally ill people. Some states have really addressed this in a way that I've never heard anybody here talk about. Guilty by reason of insanity. If somebody's insane, but they're violent and they're hurting people, you have to figure out what to do with them. But the New England attitude seems to be, well, let them go because they don't know what they're doing. So I think this bill brings up a lot of issues, and I hope that you address, by your concern, the main issue, which is protecting the first responders who now have enemies who don't worry about getting caught. So, thank you.
Thank you for your testimony. Questions? We're all set. Thank you very much for coming in today. Anyone else wish to testify on HB 59? One of my favorite two sisters.
Apologies, Mr. Chair. I wasn't planning on testifying on this bill, but Kate Horgan, New Hampshire Association of Counties, I just wanted to clear something up. County correctional facilities cannot 4-point restrain anyone that is in the correctional facility. We're prohibited from doing that, and that's all I wanted to add.
Thank you very much.
Thank you.
Anyone else? Thank you very much. That'll end the hearing. We're not doing anything else. Thank you all. Motion to adjourn. All in favor?
Aye.
The ayes have it.